And with elder law, and with so much on the line in terms of assets that you've worked a lifetime to accumulate, you need someone who knows exactly how to dot I's, cross T's, and where everything should go. So tell us a bit about the distinction of an elder law attorney.
With elder law, what we're looking at is how you are going to pay for long-term care issues, medical issues, as people tend to live longer. Medical technology has made people living well into their 90s, over 100.
Mm-hmm.
It's not unheard of.
No.
So people do really need to plan for how to pay for medical expenses much longer into the future than they did previously. Estate planning focuses on your wills, trusts, and disposition of your assets at the time of your death, whereas I'm doing more planning for living longer and planning for medical care.
There's so many misconceptions, and we see it when we speak to the seniors. We do our spiel, plan, prepare, protect with our friend Linda, but there's so many misconceptions out there. Among them, what Medicare will cover, or when Medicaid kicks in. And then yesterday you really had a great discussion on long-term care insurance, and there were people talking about whether or not they should just forego the premiums and, kind of prematurely surrender the policy. Healthcare costs are exorbitant. Talk a little bit about per diem, what some of these costs are if you're in assisted living or if you have a home health aide.
Assisted living, we really do run the spectrum from around $3,500 to $4,000 per month, up to about $7,000 to $8,000. Some of them actually go up to about $10,000 per month, and it depends on the level of care that you need in certain facilities. So
Right.
You could start out at a lower level, and then it increases as your needs increase.
As your needs increase. And normally in assisted living, under what realm are we covered? Are we in the Medicare realm, or in the long-term care insurance, or private pay out of pocket?
Private pay is generally is the way that you generally pay for assisted living, although there are some long-term care policies that will pay for assisted living, which is why yesterday when a woman that was at our presentation said that she was having a hard time paying for her long-term care premium and wanted to just abandon it because she no longer had the money that she thought she would have at that age, that she thought she was protecting by having the long-term care policy, I strongly encouraged her to ask a family member to assist her in paying the premium or continue to pay it any way she can, because she's giving up options that are not going to be available to her otherwise. If her policy helps pay for assisted living, Medicare will not help her pay for assisted living, and Medicaid does not help you pay for assisted living.
There's such a concern about depletion of assets. And I know in this woman's case, there was a concern that paying the premium would work to deplete her assets. But in actuality, if the long-term health care needs kicked in, the assisted living needs kicked in, without that long-term care policy, that's the real concern for depleting everything that you have. And again, there's such a misconception of what Medicare will cover. Am I correct to say Medicare is really short-term rehab needs?
It's short-term skilled nursing needs.
Short-term, so post-hospital stay, when you're leaving the hospital but you can't go back home. And then out of that, what they pay, the rate adjusts, correct, based on how many days?
Well, the first 20 days, they will pay 100%.
Mm-hmm.
And you can have up to an additional 80 days for a total of 100 days covered.
But not covered at 100%.
The 80 additional days, which very rarely do you see somebody that actually is Medicare eligible for 100 days to begin with, but the additional 80 days are at a copay rate.
Okay.
So if you don't have a supplemental insurance, which a lot of people don't have that either,
Mm-hmm.
because it costs a couple $100s per month. The 20% that you have to pay out of pocket can run you a couple $1,000s a month.
So, I mean, the reality is that it's scary to hear. I mean, these are scary conversations to have because these are big expenses that will come up at some point. I mean, the longer you live, which is a great thing, to live long, but it's very rare that you will have longevity in the absence of any medical needs. So we're not here to scare, we're here to help you plan ahead, because planning ahead is the only way to mitigate some of this hardship.
Well, and part of the problem is that Medicaid now has a 5-year look back.
Yes.
So we used to be able to help more in a crisis situation when we had a 3-year look back, and when a penalty for making transfers used to start running from the date that you made a transfer. Now we are a 5-year look back, and if you've made transfers within a 5-year period, your penalty is going to start when you run out of money. So it does not run from the date that you've made the transfer. So the situation has become increasingly important to plan ahead.
Yes, I mean, because again, 5 years is, we said it before the show, you could change the course of your health overnight. You could wake up healthy, have a fall, and then everything changes. So 5 years is not as short of a window. A lifetime could happen in that short window. And when we say look back period, the reason is for Medicaid eligibility, you have to meet a certain income criteria, and you have to have depleted assets down to a certain number. So in preparation for doing so, people look to get assets out of their name. That's what you refer to as that look back period.
Correct.
Before we segue into burial contracts, which is a huge part of this.
And sadly, a part that I thought that you were going to take up yesterday at the presentation, and I didn't bring it up, and we ran out of time.
We ran out of time. No, and I do as well. But you know what? We were going in there was so much information to cover that, it's almost like we should do something where we just have a talk and then like commit to spending a morning there or a chunk of time. I think that we could
do almost a day program.
I absolutely agree with that. That's something good we should speak to Lori about. But getting back to eligibility and assets that you're allowed to have, assets that you're allowed to transfer, spousal exemptions, run through some of these generally. I know it can get very specific. And then we'll talk about how Medicaid allows you, as one of the assets you can hold on to is a burial trust, a prepaid burial trust. But start at the beginning for, when it's time to do the spend down, so to speak.
For single people.
We'll do single, then we'll do spousal.
Okay. Well, for whether you're single or you're married, you are allowed to keep essential household items. You are allowed to keep an insurance policy with the face value of no more than $1,500 if it's a whole life policy, meaning it's a policy that builds value. Surprisingly, if you have a term policy which does not build value, it can be in any amount. So a $1 million term policy would be exempt.
Wow.
It doesn't quite make sense, but
you know what? Let's not bring it to their attention.
You can have one car.
What household item you said earlier? I'm sorry. Give me an example of something.
Your furniture.
Furniture, okay. Furniture and fixtures and.
Correct.
Okay.
Essential household items.
Okay.
So what is essential to you living in the community? Okay. So that would be for a community spouse. It would be everything in the home that you use on a daily basis.
Now get to the home itself.
If you are in a skilled nursing facility and there is the possibility that you're going to return home within a 6-month period, the home is exempt.
Okay.
If you are married and you have a spouse in the community, the home is forever exempt as long as your spouse is residing in the community.
The issue now becomes when that spouse needs to qualify, correct?
If that spouse needs long-term care, then there is an issue, because once they both need long-term care, they're both treated as individuals, where they both need to spend down to $1,600.
So is this the time now when we start to think about taking the house out of the name and putting it into a trust or into the name of children?
Well, unfortunately in Connecticut, although the house is exempt to the community spouse, the spouse cannot give it away while they have a spouse in the nursing home. They can sell it for fair market value.
But they can't transfer it to offspring and to children.
Right.
Okay. So spousal exemptions, you can keep your spouse in the comfort of their home.
Right. They also can retain 1/2 of the assets.
Okay.
Up to a maximum of, this figure changes every July 1st, and right now the figure is $126,420. So if you have $200,000, you split that in half. The community spouse can keep $100,000.
Okay. Let's talk about a situation I see quite often when we have secondary residences out of state. Or we have the situation where a person now crosses over from New York into Connecticut, let's say takes up residence at Greenwich Woods Nursing Home and now applies for Medicaid. The Medicaid coverage comes from
the
where?
State where you are residing. So Connecticut. So
even if you've just come into Connecticut now and your first time ever taking up domicile there is for the purpose of your nursing care.
It's residence.
It's residence. So if that's become your legal residence.
And we have a lot of that here because, as you know, some of our facilities, I think it's called Regal Care now. It keeps changing names. That's on King Street, as well as Greenwich Woods.
Yes.
They're right over the border of New York. So
absolutely, and I run into it with both funeral homes quite a bit.
Yes.
So the state of residence, and if that happens to become your legal residence, then that's where your Medicaid coverage comes from.
We just had a very interesting situation in the office where there was a woman that was in Greenwich Woods for rehab because since United Hospital closed, Portchester residents and Lower Westchester residents get sent to Greenwich Hospital.
Yeah. Oh, yes.
And so when she went to rehab, she was sent to Greenwich Woods. So now she's in Connecticut. She's eligible for New York Medicaid, but Greenwich Woods does not accept New York Medicaid. And they were waiting for her to make arrangements to move her back home under her New York Medicaid. During this time, she was no longer Medicare eligible at Greenwich Woods, so she was building up a bill at Greenwich Woods.
Wow.
We could not apply for Connecticut Medicaid because if we did, she would lose her New York Medicaid, and we knew she was going home to New York.
Wow.
So it creates...
I mean, but that is not. It's as crazy as this sounds. It's very real. I mean, this is not uncommon. I can absolutely see how this happened. I just did a pre-arrangement for somebody who lived in New York all her life and kept saying, I'm going to do it, and when her she has no blood relatives surrounding her, just dear friends who are like nieces to her, and she came in and she showed me every letter that I had corresponded over the years with the woman, and she just never came in to do it. And now she found herself at Greenwich Woods, same thing, because through hospitalization at Greenwich Hospital, that was the next step. And she was now applying for Connecticut Medicaid, although it's funny, the trust company was saying to me, you can do this through a New York contract. And that's where I say the misinformation comes in, because New York burial contracts and Connecticut are totally different beasts. And we'll explain why. Connecticut, as you know, is part of the assets you're allowed to have. Again, you can have set aside funds for your burial. It's not counted against you when adding up your net worth. They'll allow you to have up to $8,000 in an irrevocable contract, and then a separate revocable contract for an unspecified, unlimited amount for specific burial items. Whereas in New York, it's one contract marked irrevocable for any amount you deem fit. So it's two very different sets of paperwork, two very different skill sets you go in the arrangement conference with. But this woman, just by crossing that border, she lived 87 years in New York, and now welcome to Greenwich, and we're subject to a different set of laws entirely.
Well, and a lot of times I have clients that split their time between, say, Florida and Connecticut, and they'll come in for an elder law consultation, but I always refer them to an elder law attorney in the state where they may possibly also end up residing.
Let's talk about what constitutes residency. Is it a 6-month period? Is it what is it? Is it based on time?
For Medicaid purposes,
yes.
It's just being in that state.
So my parents, for example, split their time between Florida and New York. My mom probably more full-time Florida, and my dad a little less, but I'd say equal in both. So just...
Well, 6 months and a day for tax purposes, which is completely different.
Right, 6 months and a day, but for
Medicaid
purposes...
it's just physically being in the state.
So then technically you could have dual eligibility then in both states.
No,
Assuming
because once
Florida...
you apply in another state, it will terminate your approval in the prior state. And it actually asks on the application whether or not you've applied in another state within 90 days.
Okay. Now, just from your experience with having so many clients who do spend time in Florida, are the Medicaid coverage laws more favorable there?
I think Connecticut tends to be a little more strict than most other states.
I would agree.
You know, for in a lot of areas. For instance, in Connecticut, IRAs are counted. In a lot of states, they are not counted unless they're in, the distribution stage. So where you're taking your required minimum distributions. And in some states, it's only counted as income, and it's only counted as income up to the amount of your required minimum distribution.
Okay.
But in Connecticut, we see people with a substantial amount of wealth accumulated in their IRAs under the misconception that because it's in an IRA and that there's a tremendous tax liability if they liquidate it, that they're not counted assets for Medicaid eligibility, and they are.
Again, without speaking to an attorney in advance, there's so much room for error and so much room to lose so much. So let's talk about the burial contract once again. This can be funded. So it requires going to a funeral home. It requires pre-planning. It requires showing Medicaid that you do have an irrevocable burial contract set up. Now, for some people who are looking for direct cremations and direct burials, that is well under $8,000.
Although I still recommend that people set it up. Because they may change their mind.
Exactly.
It's
and
an
I've seen the 8,000 is a recent change as well. And the state did allow you to go back retroactively, correct? And
to increase your $5,400.
Yes. Okay. Yes, these laws are ever changing, ever evolving. And then the other issue becomes, with what can you fund the pre-need trust? There's a big issue about life insurance policies. I'll have you weigh in on that because you are far more an expert.
Well, actually, in terms of what actually happens with the policies, you are the expert.
I know Connecticut they do allow you to assign an insurance policy to the funeral home. So basically, you're not surrendering a policy.
Right, which is a great use of a policy because a lot of people send in to surrender their policies. The face value oftentimes is, or even the cash value, then gets spent down on medical expenses, and people don't realize that if they just assign the policy to fund their burial or funeral contract or both, that it's more valuable to them.
It certainly protects the person of whom created the policy. Let me ask you a legal question. Assuming they have a policy that covers a funeral and there's an overage, is that overage allowed to go back to the next of kin or other beneficiaries or assignees, or does it have to kick back for Medicaid reimbursement?
My understanding is it goes back to the state.
Okay, it would is cheap back to the state.
Which is fine because at least the funeral arrangements are fully covered.
Yeah, that's true. That does make sense because any monies left over in an irrevocable contract do have to go back.
And if you don't set it up a burial contract and you're on Medicaid, I believe the amount right now, and you would know better than I would, the amount that the state provides for somebody on Medicaid, I believe, is $1,800.
Yes.
So you're forced to be cremated. You don't really have the option of being buried.
It's very, very true. I mean, we've always done our best to work with people in situations, but, getting cremated, the crematory charges you $429. I mean, there are legitimate costs, and it does become logistically difficult. So we're a huge advocate of planning ahead. Again, the message today was not to scare you, but if scaring you, gets you into an attorney's office to plan ahead, then I guess we've done our job today. I just want to, before we wrap up, I want to let people know where they can find you, because I do say this very honestly. I like to recommend people and then put my head on a pillow. Donna is an expert in this field. I've watched her interact with so many in the senior community, helping and educate and answer questions, and she can be found down the road at Ivey, Barnum, and O'Mara. What is your phone number, email address? Where can we learn more about you?
My phone number is 203-661-6000. My email address is my first initial and my last name. So it's dcastronovo@ibolaw.com.
So again, we'll repeat your number once again. But the moral of the story is, let's get assets to where they need to be. If they need to come out of your name, let's do those transfers while you're happy, healthy, of sound mind, and you're not under the gun and forced to do these and facing penalties. Do your burial contracts in advance. Now, if you have a burial contract before you go on to Medicaid, I know in New York it's as simple as sending a request in writing to have a change in status to irrevocable. If you had a burial contract funded and then you do find yourself in need of Medicaid, is it just a matter of switching and then just getting the contracts in the right way, irrevocable versus revocable? But having it in advance, again, it's just something that's peace of mind.
Oh, absolutely. And also, it locks in your price.
It's so true, and that's what we always tell people about.
That is very important also.
It's cost freezing. So basically, you're paying today for the services of tomorrow. We don't literally mean tomorrow, but, you know, cemetery costs go up over the years. Our costs, you know, we don't go up every year, and I'm very honest about that, but operating costs do go up, and therefore, eventually, our costs do have to match to to account for that. So when you put your money away today, and let's say you have a funeral in 5, 10, or 15 years from now, your accounts have accrued interest. We place them safely in FDIC insured trust funds, and the money is there. The interest will offset any increases, and your family is not on the line for the difference. So it's a very, very good planning vehicle. We happen to put money into trust funds, cooperative funeral fund. We don't use the insurance vehicle. We find this to be much better for the family. No kickbacks, sales commissioners.
They also do receive statements.
Yes, you receive annual statements, and at any time you can call to find out an account balance as well. And your money will yield the same interest whether it's revocable or in an irrevocable
And we do
contract.
have to stress that they do have to go to the funeral home and actually pay for the contract, because some of my clients are surprised that they just can't put aside money for the burial contract.
Yeah, I mean, if you're actually setting up a trust with a funeral home, yes, it does require you to come in.
Yes.
But come in. We have a very nice, inviting office, as does Donna. But plan today, folks. Plan today for tomorrow, and don't wait for the last minute. You know, we don't want to think of the worst happening, and planning doesn't mean that the worst will happen, but do it for yourself, your peace of mind, and for the ones you love. So thank you, Donna.
Thank you, Jen.
203-661-6000, Donna Castronovo with Ivey, Barnum, and O'Mara. And this is Jen Graziano inviting you to read more on our website, coxandgraziano.com. And as always, thanking you for taking the time to listen as we took the time to talk. Have a great day, Greenwich. Bye-bye.